Good afternoon, everyone. My name is Samir Varma. I'm a partner in Thompson Hine's International Trade Practice. Welcome to today's webinar, and thank you for joining us. I am delighted to introduce you all to my colleague that will be presenting with you today, Francesca Guerrero. She's also a partner in our international trade group. Before beginning, I obviously would like to wish everyone good health and hope you all are safe and well in what is obviously a different and challenging time. Also, before we begin, I just want to go over a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. If you have any questions during today's webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will try and answer as many questions as possible at the end of the webinar. We are offering CLE credit for today's webinar, so please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel, also located on the right side of your screen. The form provides instructions as to where to send the completed form, and I will announce a tracking code at the end of today's program. Also note that in the handout panel, you can download a copy of the PowerPoint slides and bios of today's speakers. Again, thanks for your interest in today's program, and we'll go ahead and get started. So today, we're going to cover a number of topics related to CFIUS, or the Committee of Foreign Investment in the United States. I'll start with an overview on CFIUS. We'll talk about the expansion of CFIUS and the regulations as part of the FIRRMA, or the Foreign Investment Risk Review Modernization Act, including expansion to definitions of non-controlling investments and how it affects real estate. We'll talk about some accepted foreign investors or states. We'll go over some procedural changes and new filing fees, as well as discuss the mandatory filings. We'll talk a little bit more about case studies and trends, and we'll end with a question and answer session. So to start, we'll just to get us all on the same sort of footing here, I wanted to start with just a basic overview of CFIUS. CFIUS is an interagency committee headed by the Department of Treasury. It is authorized essentially to review certain transactions involving foreign investment in the United States, and certain real estate transactions by foreign persons, in order to essentially determine the effect of such transactions on the national security and to review for national security risk. It considers both national security threat posed by the foreign investment, by the investor itself, as well as vulnerabilities here in the United States. We'll go over a lot of this in today's webinar. As I mentioned, it is headed by the Department of Treasury, or chaired by the Department of Treasury, but it is a 9-agency panel, and it includes representatives from Justice, Homeland Security, Commerce, Defense, State, Energy, the Executive Office of the U.S. Trade Representatives, the Office of Science and Technology and Policy, and also, as appropriate, they often will get other agencies involved as well, including the Office of Management and Budget, Council of Economic Advisors, National Security Council, National Economic Council, Homeland Security Council. All these different agencies can weigh in. So you can see that there's a lot of agencies involved, a lot of input depending on the sector of U.S. business as well as the foreign investor that is involved. Now, since 1988, CFIUS has had the authority and the ability, through its own volition, either before or after a transaction is closed, to review transactions that result in foreign control of a U.S. business. And note that the president has the authority to block any transaction as well. Now, historically, notifications to CFIUS were solely done on a voluntary basis. That is, companies that felt non-U.S. investment particularly impacted national security in some meaningful manner could proactively submit a voluntary notification to CFIUS. Obviously, that's sort of odd, right, to have a process where companies could put themselves in front of a government agency for review, but obviously the benefit was that they could obtain safe harbor. That is, CFIUS could not thereafter review the transaction, nor could the president block or unwind a deal. Now, certain filings are mandatory depending on a number of factors, and these factors are changing. We do want to note that when we talk about control, I mean, control is defined very broadly. That is, it's not just a 50% ownership rule, but rather it could include different situations where foreign persons are involved in approving key business decisions, et cetera. And as we're discussing now, even non-controlling investments can be subject to CFIUS review. So CFIUS, the way it often interjects itself in different transactions is that it has the ability to pursue certain mitigation measures in order to alleviate any national security concerns present in any sort of potential transaction. There's a whole host of mitigation measures that they could implement, including national security agreements, supply chain agreements, et cetera. I will note that mitigation agreements do seem to be on the rise. And so it behooves companies who are involved in any, non-US investments that could come under the purview of CFIUS to be proactive in planning for any potential mitigation measures that could be implemented or requested of them. We also CFIUS can recommend that the president block or unwind transactions where risk cannot be mitigated. Recently, just in the past few years, there have been at least three transactions that have been ordered unwound through divestiture. And that's just only since 2018, which is a big uptick since prior to that, in the 6 years prior, there had been another 4 transactions. So I started off just to give a brief overview, just so that we're all on the same footing, but I'll turn it over to Francesca to go over the expansion of CFIUS through the new regulations.
Thank you, Samir. We can go to the next slide. So in 2018, Congress passed the Foreign Investment Risk Review Modernization Act. And I'm sure everyone has been hearing about this for nearly the last 2 years. It authorized CFIUS to expand, and it authorized and directed CFIUS to expand its review in many ways. Also authorized them to put in place filing fees, make certain procedural changes. And what we've been seeing since August 2018 is the rollout of this bill. So in February, and there was a final rule that implemented pretty much all of the remaining reforms. We've actually seen some more amendments since then, but FIRRMA has been in an implementation process since August 2018, and basically fully came into force in February 2020. One of the key changes that happened in the interim was the creation of a pilot program that focused on covered investments in companies that produce or design critical technology. And as we'll discuss in a minute, that has been rolled into and sort of superseded by the final rule. Next slide, please. One of the biggest changes that happened in FIRRMA is that Congress gave CFIUS jurisdiction over not only foreign acquisitions of control of U.S. businesses, but also over what they call covered investments, which you might kind of call a non-passive investment in certain businesses. The final rule calls these businesses technology, infrastructure, and data, TID U.S. businesses. That's a defined term you'll see a lot. And so these covered investments, which we will dig into what a covered investment is in a minute, but these TID U.S. businesses are ones that either produce, design, manufacture, et cetera, critical technology, and we'll talk about that. Ones that perform critical infrastructure functions in relation to certain critical infrastructure industries, or that maintain, collect sensitive personal data of U.S. citizens. The last one is actually the one that I think is like the hottest area right now, despite the pilot program and the focus on critical technology. Most of the most of the divestitures and most of the sort of blocked transactions in the last year or two, I would say, actually involve companies that maintain sensitive personal data. So that's really something to be mindful of, and we'll talk through some examples in a bit. Next slide. Okay, again, so what is a covered investment? What is this non-passive investment? It's one that gives a foreign person access to material, non-public technical information, one that gives them a seat on the board or whatever the governing body is, and that can include a non-voting observer seat, or any other involvement except just by voting shares in the substantive decision making regarding whatever of the CFIUS businesses we're talking about, so the critical technology, the infrastructure, or the personal data. And what this is really kind of trying to target is strategic investors who are making investments because they want to kind of learn about the industry and this business, as well as some of the bigger institutional investors who typically would, I think in the past, have wanted to have these types of rights when they make an investment. Keeping in mind, like Samir said earlier, CFIUS's definition of control is so broad that many of these might have been captured even under the old definition of control, but this brought a lot of clarity to what's a covered investment. It brought a lot of clarity to this sort of gray area as far as what is subject to CFIUS jurisdiction versus what's not. There is a narrow exception for, actually, can you go to the back last slide for a second, for limited partners that invest, limited partners that invest in a company and have a seat on an LPAC, a Limited Partnership Advisory Committee. There's a list of authorities that they can't have, such as the right to sort of approve GP compensation and such. And if they meet all of those, then having a seat on the LPAC is not considered to trigger this sort of covered investment right. Okay, next slide, thank you. So getting into what are these CFIUS businesses? The T, critical technology, is basically what was covered by the pilot program. In some ways, it's one of the easier ones to identify. Although, frankly, I actually think CFIUS and their regulations did a good job of providing some bright line rules. I think they could have gone a different direction, and I think this is pretty good. But it's defined by reference to other regulatory regimes. So companies that are developing, manufacturing, export control technology under the ITAR, which is defense items, commerce control list, nuclear items, various agents and toxins. Those are all companies that are sort of key companies. There's another prong that will affect whether or not there's a mandatory filing requirement, but this determines whether or not it's a technology company. Next slide, please. So an I is an infrastructure company, one that's involved in critical infrastructure. There's an appendix at the back of the new rule, or the February rule, that lists a number of areas ranging from companies that lay telecom cables, companies that are involved in producing satellite systems, companies that have certain sorts of energy generation assets, certain financial infrastructure is covered. So it can really range. When they say infrastructure, they mean that broadly, ranging from finance to transportation to ports to pipelines, all very broad area. But the appendix has another column where they talk about sort of what the role has to be with respect to that asset. And generally, you have to be operating or managing the asset in order to be considered involved in critical infrastructure. Next slide, please. Oh, and here we have an example of, how this appendix looks. And this is part of the diligence process, I would say, for both companies seeking investment and for investors. Looking at the activities that this U.S. business is involved in, and determining whether it meets these criteria for critical infrastructure. Next slide. What's a data company? A sensitive personal data company. That's, you know, again, sensitive personal data ranges from, you know, health-related data to geolocation data to, you know, your social security number and other personal identifier data. For most types of sensitive personal data, you have, in order to qualify as a CFIUS business, you either have to maintain or collect data on more than 1 million individuals, or you have to target your services to U.S. government personnel. I'm sorry, I'm having a little problem with my screen, which is why I was stopping there. There is no threshold for companies that maintain or collect results from an individual's genetic tests that constitute identifiable data. It's automatically a TID U.S. business. It doesn't matter if you only have 5 people's identifiable data, but it does have to be identifiable. So if it's you know, mixed together and not tied to any individual person, then it does not count. Next slide, please. Real estate. This is another big area, and actually, before we go there, just to focus on this new covered investment of TID U.S. businesses, I think it's worth mentioning as well that whenever we have an acquisition of control, regardless of the type of business, CFIUS has jurisdiction. So, you know, if there's an acquisition of control, you may not necessarily think you want to do the diligence, figure out if you have a technology or data infrastructure company. However, I think that this is a really strong signal about the types of businesses that CFIUS considers posing a national security vulnerability. So, you know, if you are looking to acquire one of these businesses, you know, it's a sign that you should definitely, you know, give a closer scrutiny as to the national security issues that might be involved. So switching gears to another aspect of FIRRMA, the legislation gave CFIUS the authority to review acquisitions of real estate that are pretty narrowly scoped. So it needs to be in a sensitive location, and as we'll see on the next slide, it's actually pretty specifically defined that you can use, you know, geolocation type maps to figure out if your real estate is covered. But this is a big shift from previously when, if you were doing a greenfield investment in, say, a wind farm, you could buy some land, start working on the plans to build your wind farm, and CFIUS would not have jurisdiction to review it. If you had been investing in a development project that someone else had started the development process for, then they would have jurisdiction, but greenfield investment was not covered. So now, if a greenfield project involves sensitive real estate, it would be covered and subject to CFIUS review. Next slide, please. You know, I'm not going to go into this in a lot of detail, but the rules specify a number of military installations and other government facilities, and covered real estate is defined by proximity to these specific locations. You know, even the ports are specified by type of port so that you can determine whether it's covered. So, and CFIUS recently put a tool on its website that makes it even easier to determine whether you might have sensitive real estate. Next slide. In order to be considered a covered real estate transaction, it doesn't necessarily mean you have to have title to the real estate, but it does mean that you have to have 3 of these 4 rights. So you have to have the right to physically access the site, exclude others from accessing it, affix some kind of structure or object, or improve or develop the site. So various concessions that don't involve transfer of title can still be considered covered real estate. There are certain exemptions for like single housing units, real estate in an urban area, exceptions involving accepted real estate investors, which we'll talk about in a bit, tracks the accepted investors for other transactions. Next slide, please. Here we just wanted to highlight, a few other exemptions that are kind of specific. If you're leasing space to open a business in an airport, that's not covered. If you're leasing commercial office space, generally not covered, although it depends on how, what a percentage of the building you're going to occupy. And indigenous community real estate is not covered. Next slide. So we also wanted to talk about how we think COVID-19 might impact what's happening, what CFIUS is thinking about in terms of what areas are national security vulnerabilities. And, Samir, please chime in if you have some additional thoughts here. But I think that it's highly likely that we're going to see increased scrutiny on companies that are producing relatively basic medical supplies and pharmaceuticals. So it's not necessarily cutting edge products that were probably already scrutinized, but your companies that are making gloves and face masks and respirators, things like that. I think you'll see increased scrutiny on those areas. It might be that they are defined to be considered critical infrastructure or possibly critical technology, in which case even these non-passive investments that we talk about would be scrutinized. That would involve CFIUS changing some of its definitions, but there's actually one of the critical infrastructure categories includes companies that have had a certain number of defense priority rated orders in the last few years. I'd have to look at the calculation to see the exact amount. So that means if you're a company that's been producing a bunch of, say, face masks under defense priority orders, selling them to the government, you might sort of backdoor find yourself considered a critical infrastructure company, even without CFIUS having to change its rules. So I think that we'll see an increased focus on these types of companies. And can I see the next slide? Is this also COVID-19? Sorry, so we'll go back. I think what we'll see is even if CFIUS doesn't necessarily want to block investment, because these are all businesses that obviously people want to see grow and have resources to manufacture these items, we might see increased use of mitigation with respect to these, like potentially using some of the tools they already have that would require companies to keep supplying the items to the federal government. That might relate to, containing or moving production, increasing production perhaps in the United States. So we might not necessarily see these deals blocked, but we might see the government more actively engaging in the process to approve them.
Yeah, and I think, if I can just jump in, so I think that's right. And I think hidden behind all of this, a lot of the changes to CFIUS were really geared towards, China. Obviously China isn't mentioned anywhere in the regulations or anywhere in sort of FIRRMA or anything like that. But at the same time, years ago, when the president first came aboard, a lot of the CFIUS, a lot of the concern about investment in the United States was related to China. And now that we're amidst this sort of pandemic, a lot of the materials a lot of the PPE and many other materials that the United States may be in need of, that may also be coming from China. And so even investment in these areas, there's going to be increased scrutiny on how we view supply chains, how the U.S. views the supply chains and availability of the products, and this particularly if there is any sort of monopolistic tendencies where companies could have a monopoly over some of these products over, particularly that related to China. I think that's another big issue here too.
I definitely agree. Yep, no, I definitely agree, but please move on. And I think I'm turning it over to you, Samir.
Oh, right, okay. So, Francesca's been talking a lot about the FIRRMA, the new regulations, and within the new regulations, there is this concept of accepted foreign investors or accepted foreign states, and they're defined essentially as those states with compliance laws and regulations similar to those of the United States, particularly concerning foreign investments, and foreign investments assessed for national security purposes. So, the initial list that we have written here includes Australia, Canada, and the United Kingdom as accepted foreign states. And there's actually a quote that says that these are accepted foreign states due to their, quote, robust intelligence sharing and defense industrial-based integration mechanisms with the United States. And so what the U.S. is trying to do is look at other countries and how they view foreign investment and then add them to this quote unquote white list. The list may be expanded in the future, but note that it doesn't cover every transaction or a certain control it doesn't cover control transactions. But anyway, there are certain requirements for any investors from the accepted foreign states that they must meet in order to be eligible for the exemption, and we've listed them here. Now, this is not meant to be a full list of everything that it covers. There are a number of different criteria that they've put out. One of the more important ones, or the key ones we've seen, is this bottom bullet where you must have minimum accepted ownership by persons who essentially qualify as accepted investors. It's also different if you're a public entity or a private company. There's indications that if you're a public entity, it's a majority ownership must be accepted or qualify as accepted investors, whereas if it's a private company, the percent ownership must be roughly 80% that qualify as accepted investors. So it's definitely changing, and we'll have to keep a lookout for how this plays out. And there's also certain disqualifications, several disqualifications. Past and future missteps may disqualify you as an accepted investor if you violated certain U.S. laws or regulations, including Office of Foreign Assets Control, OFAC, economic sanctions, export controls, and other sort of areas. If you've been part of a CFIUS filing in the past and you've committed a violation of any mitigation agreement, I mean, really, if you've committed any sort of CFIUS issue, like you've had a misstatement on a CFIUS filing, you may be disqualified as an accepted foreign investor. Again, and then obviously after the fact, CFIUS can come back and choose to review closed transactions if they've been disqualified within 3 years after the closing of the transaction. So it's a retroactive issue here. Again, this concept does not apply in instances where the foreign direct investment will result in control of the U.S. business. I just want to quickly touch upon some other procedural changes, including filing fees. There have been some additional changes. Most importantly, I think FIRRMA created a process for this light CFIUS filing called a declaration. This one of the more key requirements of this is that it does not require detailed personal information about the directors and officers. Often this is not only delays the filing process, but foreign investors whose information is often required, they don't often want to give that type of information. Note that this light declaration can be filed for both a voluntary or a mandatory filing. We'll get more into mandatory filings in a bit, but you can do these light declarations even if you're not subject solely to the mandatory filing requirement. You can do it for the voluntary process as well. There's after there's a 30-day requirement here. So instead of the normal 45 days under a voluntary filing, you have to submit the short form or light declaration 30 days prior to closing. After those 30 days, CFIUS can take one of these 4 steps. They can clear the transaction, which essentially provides the safe harbor. And so you don't have to be worried about them coming in and initiating a new review thereafter. Note that safe harbor only applies to this specific transaction on the declaration. So there's no safe harbor for subsequent or incremental acquisitions. They can direct the parties to file a full notification and then become subject to the additional review process. They can decide to initiate its own review. Or what's interesting is they can make no decision. And this is sort of like what's referred to as like a shrug the shoulder event. I mean, in one sense, the filing company has, when you've filed 30 days in advance of your transaction, you've sort of discharged your statutory duty to make a filing in the requisite amount of time prior to the closing. But it doesn't necessarily mean that the CFIUS review is over. They can still come back and direct the parties to file a more formal notice, or they can initiate its own review. So if you've filed it and you've done this light declaration 30 days prior, it doesn't mean that it's necessarily over. And that's been an interesting situation since this has happened.
Yeah, and I think just to add to that, Samir, what we've seen is that because you're not guaranteed closure, a lot of people who have to do a declaration choose to instead file a full notice, so they're guaranteed a decision. And I think that, part of the fear is that if you file a declaration, CFIUS might just take 30 days, do nothing, and then if you really want a decision, you have to start the process, from the beginning with the notice. So you kind of like tacked on 30 days to your review timeline. But I think this is something to really watch as they release more information and show how many transactions actually get a clearance under a declaration. If numbers are, become significant, I think people might start using declarations more.
Yeah, that's absolutely right. I think that, and because there's so much concern about closing dates and when deals are going to close, that adding an additional 30 days could really hinder the process. And so companies need to be aware that there is this idea that this CFIUS may not make a decision, and then you're stuck doing even for a longer period of time before obtaining that safe harbor. So if companies do choose to file a notice voluntarily or directed by CFIUS after filing the light declaration to complete a more formal notice or something similar, you would have the opportunity to ask for a pre-filing review. Note that this is not available for the light CFIUS declarations. You can't do a pre-filing review of the short declaration, but you can for the official notice. And requesting a pre-filing review basically allows you to start the interaction with CFIUS and hone in on certain aspects of the notice that CFIUS may pay particular attention to, and just get a sense of what they're thinking. Once you file the actual notice, it must be accepted by CFIUS in order to commence the statutorily prescribed initial review period of 45 days. But simply put, as filings have increased over the years, I think CFIUS has taken longer to initially accept a notice, up to a few weeks or even longer. So it's not that you submit your notice and immediately it starts the 45-day period. They have to accept it. Once accepted, they have 45 days to finalize any decision, or they can commence a more formal investigation, which starts another 45-day period, and they can add on 15 days to that if needed. If the parties can't come to an agreement with CFIUS about the mitigation or other measures that are being implemented, the transaction would then go to the president. If it goes to the president, then the president has 15 days to basically issue a directive blocking or unwinding the deal. There has been more increased emphasis on mitigation measures, and there's in both 2016 and 2017, CFIUS required mitigation measures for 12% of the transactions it evaluated. There are penalties for failure to comply with mitigation of up to $250,000 per violation. And this is key, and it can quickly aggregate. I think last year in April of 2019, CFIUS posted on its website the announcement of a civil fine of $1 million on an unnamed anonymous party for repeated breaches of a mitigation agreement going back to 2016. Including, quote, failure to establish requisite security policies and failure to provide adequate reports to CFIUS. So a couple of things stand out to this. The party wasn't named, which is good, although even though there's no requirement they keep the party anonymous, I mean, I query whether they will continue to do that in the future. And obviously the fact that, $1 million is more than the $250,000 limit. So it's query how many different violations the company had that led to this $1 million fine. But even almost more importantly, CFIUS decided to reopen the investigation and essentially start a new CFIUS review. This was 3 years after the original mitigation agreement. So that's a pretty significant thing to do, to not only institute a penalty, but then reopen your CFIUS review into the actual transaction. I want to quickly note the proposed filing fees. CFIUS recently implemented filing fees. I guess the size is proposed, but it's sort of a misnomer since they are in effect now as of May 1st, but it's just part of an interim rule. There's still a comment period up until June 1st, although we don't really expect any changes to this. You can see from this chart that there's a range from no fee up to $300,000. The CFIUS has stated that it could waive portions of the fee or the entire payment if there are extraordinary circumstances related to national security. Again, notice that this only applies to the official notices and not those light declarations. So some quick thoughts on the impact of COVID-19 on all of this. Mentioned previously that CFIUS has already been experiencing delays on accepting notices and starting that 45-day statutory review period. We think that COVID-19 can only sort of impact this even more. The government obviously is not acting at full capacity, and so you get the sense that there may be some backlog of transactions. That said, statutory guidelines are still being met. So once the 45-day period begins, they are sticking to that. It seems like they're sticking to that. We'll have to see how everything plays out. Obviously, mitigation measures may be impacted. There may be some emphasis on keeping production in the United States for certain items like PPE or other related items that may just bolster the U.S. economy. I think that there's going to be a larger emphasis on continued supply to U.S. governments with letters of assurances for that continued supply and especially related items. Francesca, I don't know if you want to jump in or if you want to move on to the next one.
Just only one comment, I guess. One reason I think that, despite the fact that government officials are, I'm sure, all teleworking, so it's not like the government's closed. I think that there are delays because a good part of the process involves reviewing classified assessments of the foreign investors, and so they have to figure out how to get that material, make it accessible to the committee members as needed. And so that's one reason that things, I think, are slowing down, certainly pre-starting of the clock.
That's right. Yeah, I'll turn it over to you, Francesca, for the next part of the webinar.
Great. So mandatory filings, that was one of the big changes that came with FIRRMA. As Samir mentioned, previously all filings were voluntary with the understanding that CFIUS and ultimately the president had the authority to unwind any transaction that wasn't reviewed and cleared. But after FIRRMA, certain areas, certain types of transactions were made mandatory. The only thing that you're required to file is one of those short form declarations. You're not required to file a long form notice for any mandatory filing, but many parties choose to file a notice anyway because they want to guarantee that they will have a final decision. They've changed the rules so that the mandatory filings must now be filed 30 days prior to closing. I think the pilot program was 45 days. And of course, you know, for the government, 30 days seems like nothing. For the private equity and venture capital world, 30 days seems like a lifetime of having to wait. But you know, that was a concession on the government's part. The two types of mandatory filings are any covered transactions, so acquisitions of control, or covered investments in a key U.S. business, so one of these critical technology businesses. And we're going to talk a little bit more about what those are. And any foreign government acquisition of a substantial interest in the technology infrastructure data, TID U.S. businesses. So those are the two categories of mandatory declarations, and we'll get into detail. So under the current rules, which are likely to change very soon, in order to have a mandatory filing related to technology, you first have to have a business that produces critical technology, manufactures or fabricates it. And that critical technology has to be designed for or used in connection with the business's activity in certain industries. And so they have a list of NAICS codes for industries like aircraft manufacturing and nanotechnology. If your critical technology, say your export control technology, isn't related to one of those businesses, then you're not considered you're not really considered a T business, and so a mandatory filing is not required. The problem that I think a lot of companies ran into is that it's really hard to figure out what industries your products might be designed for. It was just a little hard to hang your hat on the fact that it's not tailored for one of those industries or used in connection with your own activity in an industry, because you might be active in many industries, especially if you're producing software or something like that. So the rule did give us a little warning that they are planning to shift this definition closer to alignment with export control restrictions. And I think that's the next slide. Okay, it's actually not the next slide, but we'll talk about what they're going to do in a minute. There are certain exclusions to the mandatory filing requirement. They added in the new rule, this is another change from the pilot program, that if the business was a T business solely because it produced some sort of encryption technology or encrypted item that was eligible for export using license exception E and C, it's no longer mandatory, because there are a lot of companies that produce like software apps, just as an example, that have encryption that is technically controlled, but you can export almost anywhere you want to export it under license exception E and C. So those companies are being caught in this net, and so they've kind of released them from the net in these current rules. Another exception would be if the foreign person's indirect investment is solely through a company that is subject already to a security control agreement, a voting trust agreement, or something else used to offset FOCI. So that's going to be a company that's doing something that involves security clearances. And, the second prong, operating under a valid, facility security clearance. So those are two exceptions. But then next slide, please. They are looking to change the definition of technology, like we mentioned, so it aligns with the way the export control regimes work. So instead of what you do right now is you say, okay, do we have a covered investment? Is it in a company that has critical technology? Is it involved in one of these industries? Now the industry prong is going to be removed. And the question is going to be, whether the critical technology that the business has would require an export authorization or license if it was provided to the foreign investor. And this is going to be really complicated analysis, but I think it's going to be a complicated analysis with something of a bright line once you go through it. It's going to, the new rule proposes not only to look at the direct foreign party that's investing it, but also certain foreign parties up the chain of ownership, including those who have a 25% voting interest in the foreign party. So as a hypothetical, let's say you have a UK company, or let's say a French company that wants to invest in a Silicon Valley company with some critical technology. The French company is going to have a seat on the board, so they trigger the covered investment rules. And the French company has several shareholders, including like a Chinese shareholder, German shareholder, Americans, you know, who knows. Any of those shareholders who have more than 25% interest, you have to look at whether an export would be required to share that technology with those investors, as well as the company directly investing. The proposed rule is open for comment until June 22nd. So, you know, after that, we will likely see, you know, an amendment come into effect. Okay, next change. Foreign government, substantial interest. As we mentioned, it involves any investment where a foreign government would have a voting interest of 25%, direct or indirect. Well, the calculation is a little bit more complicated, where a foreign person would have a 25% investment in U.S. business, as a TID in U.S. business, and that foreign person is 40% or more controlled by a foreign government, and that can be direct or indirect. There's a minutia level of regulations about how to calculate this interest, but if a company has a 55%, if a foreign government has a 55% ownership in a mid-level parent, that's considered 100% ownership when you're doing the calculation. So in any actual parent is considered 100% ownership. And there's some exceptions that were added in the final rule that disregarded certain limited partner interests and instead focused only on a foreign government's interest in a general partner. So that's really kind of a bone to the private equity space that has limited partner investment from sovereign wealth funds, for example. And there's also some exceptions related to investment funds that investments in air carriers that hold certain certificates. They're excluded from this. But you kind of want to start at the beginning and then figure out if one of the exceptions fits you. Next slide, please. Okay, so here I think we've gone through a lot of the rules and the amendments, and we wanted to delve into a few case studies just to show what's been happening recently. And we did pick out a few case studies that we think are particularly relevant in the COVID-19 space. Samir, am I starting the case studies or are you starting these?
Either one. I mean, okay. Why don't you go ahead and start with Qualcomm?
Okay. So Qualcomm, back in 2018, Trump issued an executive order to prohibit the acquisition of Qualcomm by Singapore-based Broadcom. And Broadcom had, taken a lot of steps to, bring itself more into the United States. I think that they had proposed opening an office, but still, or maybe had even moved headquarters to the United States. But still, CFIUS was looking through to the ultimate foreign ownership, which was in Singapore. So it was considered a foreign company. And, according to reports, the concerns by CFIUS were really focused on both the vulnerabilities and the critical importance of Qualcomm and on, the threat posed by Broadcom's relationship with foreign entities. So, as we said at the beginning, any CFIUS assessment involves looking at the vulnerabilities posed by the U.S. business and the threats posed by the foreign entities. Here, Qualcomm is a major player in the semiconductor space, which is a national security focus of the administration. We just saw a couple of weeks ago an executive order related to certain semiconductor components in the power grid. I'm sorry, certain semiconductor components produced by foreign adversaries. And so it is clearly an area that CFIUS considers a national security vulnerability if it were not to be under U.S. control, not accessible to U.S. companies and the U.S. government, and just industry generally speaking. There's then a threat component, and they look at the relationships that the foreign company has with, companies like Huawei, for example, also a player in the semiconductor space, and that all goes into their threat assessment. So, again, quote from Treasury officials that it was important that the dominant role, a trusted company hold the dominant role that Qualcomm does, and the U.S. telecommunications infrastructure. But it's also, semiconductors are all sorts of connected devices. I think telecommunications infrastructure is considered very broad here.
Yeah, I think, Francesca, even in this case, that there was a huge political aspect to this. And what you're referring to is spot on with the Huawei issue. I know that there was an argument that Broadcom might cut some of Qualcomm's investment in 5G wireless technology, basically creating like a market opening for China and for Huawei to come in and be a more dominant position. It was that was one of the things that CFIUS, even when they were responding to Qualcomm, with a letter that they included among many other sort of issues here, but they were concerned specifically about that threat. And even Qualcomm was Qualcomm was responding with letters back to Congress and open letters to Congress, talking about how they were going to invest billions of dollars in U.S. manufacturing and training of engineers and all sorts of things. And it didn't really, alleviate any of these fears.
Yeah, and the interesting thing also about, that's all very true. The interesting thing also that we don't note on our slide, but this was kind of a hostile takeover initiative by Broadcom. So this was not sort of a, two parties pursuing a mutually desired transaction, but this is the U.S. government intervening in Broadcom's role as an investor in Qualcomm already. So yeah, they're definitely very sensitive in this industry.
So I can talk about the next one. So the next one we wanted to discuss was Grindr, and this was Kunlun Tech Company agreed to CFIUS to sell its holdings in the dating app Grindr. You'll note, obviously, that this is an unwinding of a deal after the transaction had already been completed. So, Kunlun had acquired Grindr through two separate deals in 2016 and 2018. They did not submit the acquisition for CFIUS review, and then CFIUS came back and requested that Kunlun Tech sell its holdings in the app. And this is sort of like one of those rare examples where it was after the fact. Some of the concerns that CFIUS had was on the sensitive personal data, and including it was personal information. I think Grindr's kept personal information, including the user's location, all the messages they were sending, and even some health-related information, such as HIV status. And this was of concern. The sensitive personal data was of concern to CFIUS. So they ordered Kunlun to sell the company by June 1st, 2020. And pending the sale, the Chinese entity was barred from accessing Grindr's data. It had to shut down its China operations, have majority members of the board from the U.S., keep Grindr's headquarters in the U.S. So a lot of mitigation measures were implemented during this period of time when they were ordered to unwind the deal or sell, or not unwind the deal, to sell its holdings in the app. They did finally sell Grindr back in March of 2020 to a U.S. company. Although there's been conflicting reports whether CFIUS approved the deal, whether they have approved the deal just yet. A similar case, it's another instance of unwinding of a transaction after a deal has already been completed, was the StayNTouch Inc. Acquisition by Beijing Shiji Information Technology Company. As noted on the slide, StayNTouch is a mobile hotel property management system. They have a large database, personal data, credit card details. Again, this was one of those where the investor made an initial investment over it and then fully acquired the company in 2018. It did not undergo a CFIUS review. And so CFIUS came in and was concerned about the data that was collected by StayNTouch. And so the executive order, they gave Beijing Shiji Information Technology 120 days to fully divest its holdings, including all IP technology and data, and also was required to restrict access to China to any hotel guest data. This sort of also highlights the fact that there's really no sort of statute of limitations on CFIUS coming in and reviewing closed transactions, and so it highlights the need or emphasizes the need to go in prior to a transaction being done and obtaining safe harbor, since there's no risk at that point of CFIUS coming after. And obviously, both these last cases, Grindr and StayNTouch, highlight this emphasis on sensitive personal data, which is also reflected in a lot of the new regulations and the things that Francesca was mentioning earlier.
Right, and there was another one that was similar. We don't have a slide on it, but Patients Like Me was also in the last 2 years another company that was an app acquired by a Chinese investor that was ordered divested by President Trump. So this is clearly an important sensitive area for CFIUS. I think that from what government officials have said, one of their primary concerns is this data being shared with foreign governments or other actors who might use it for blackmail. So they're trying to protect, protect information in that way. And that's one reason that, companies that target U.S. government employees are, considered sensitive personal data companies, regardless of how many they have.
That's right.
Okay, so one thing that we wanted to highlight with a couple of case studies is some sort of special circumstances to think about in the COVID-19 space. One of them is bankruptcy, and then one of them is loan default. So we have a couple of case studies involving transfers of assets in bankruptcy, which are subject to CFIUS review. And that's really the point we want to make, is that even if a bankruptcy court approves the transfer of assets, if it's a foreign investor, then CFIUS may step in and decide to unwind or block the deal. The other situation that, in these uncertain economic times you may see is loan defaults that lead to the transfer of assets. Generally speaking, CFIUS does not have jurisdiction over loans, but when the time comes that some sort of collateral would actually be transferred, they do have jurisdiction over the transfer of those assets. So as we're all wrestling with these economic issues, it's important to keep that in mind. So as a case study, the A123 bankruptcy, that was, a few years ago, but we wanted to highlight it. it was a battery maker that had received federal funding but had gone into bankruptcy. Battery technology generally is considered, I'd say, a critical technology. The highest bidder was a Chinese auto parts giant, Hine Group, and they were essentially approved by the bankruptcy court, but pending CFIUS review of the transaction. There was actually significant lobbying by U.S. lawmakers and the stalking horse bidder in that situation who lost out against CFIUS approval. But ultimately, CFIUS did approve the deal subject to spinning off a 123 government unit. So they had a unit that specifically designed battery technology for the government, and that was sold to another US-based company. So there was also a question in bankruptcy about whether the stalking horse had acted in bad faith in lobbying against the deal, and it led to a reduction in the breakup fee that they were supposed to receive. So all of these issues, fun issues to think about in a bankruptcy context. Next slide, please. Another more recent example involved Westinghouse, which was, at this point, has been reduced from its once size to a company focusing on nuclear power plants specifically. And it went bankrupt after, it went bankrupt. I won't go into the backstory. And its parent, which was already a Japanese company, Toshiba, was, looking to offload these assets, and it created quite a political situation as both the Japanese and the U.S. government and potentially other governments were very concerned about maintaining control of this company that's one of the few companies involved in operating and constructing nuclear power plants in the world, in hands that they considered trustworthy. So eventually a Canadian company, Brookfield Asset Management, purchased Westinghouse, and CFIUS was one of the many agencies that was involved in sort of approving this transaction. So yet another example of assets being sold in bankruptcy, but when there's a issue of national security, an additional level of complexity being brought into the picture. We don't unfortunately have any slides talking about loan defaults, but I think that would follow the same scenario. So I think, Samir, we are ready to open this to questions if anyone has some questions. And while people type them out in the question pane on the right-hand side, we can throw a few out. Samir,
sure.
Just as one question I had, so what have you seen in terms of increased filings or other impacts now that the covered investment rules have rolled out? And obviously we had the pilot program for a year in advance. What have you seen in the market after those rules came out?
I think that's, yeah, I mean, there has been an increased number of filings, I think, both by not only by general partners and limited partners who are investing in sort of critical technology spaces. I think actually there may have been more filings than were actually required under some of the pilot program, just simply because the pilot program was broader than I think what people really realized. And so I think there had been a number of more filings, and I think the new regulations are geared directly towards that aspect, that trying to limit the scope, limit it to real national security concerns. And the idea of what CFIUS is now doing, what they're trying to do is to use our existing national security related export controls or related laws to hone in on exactly what filings are required. I mean, what do you think? What have you seen as well?
I think that that's all true. I agree with that. I had seen a surprising amount, I'd say in the last year and a half, a surprising number of companies really tailoring their investment structure to avoid CFIUS jurisdiction under the pilot program, so that like limited partners, for example, giving up rights that they might otherwise acquire in regular course, or general partners managing to get provisions that allow them to change the limited partner rights if necessary to keep it out of CFIUS jurisdiction. I saw a good bit of that, but I think that despite that, obviously there's increased filing fees just because of the increased CFIUS jurisdiction. I'm really curious to see whether and how the changes, like you said, to align it with export control regimes and the accepted investors, whether that changes the leverage that limited partners have when they're negotiating these agreements, and whether we see more limited partners pursuing some of these rights, maybe willing to make a filing, maybe qualifying as accepted investors. But I think that'll be interesting just to see where the market goes there. But I think that the general partners actually got a lot of power, and sort of existing management got a lot of power out of the pilot program to leverage minority investors into giving up certain rights. So I'm curious to see what happens now.
I think that's right. Do you see that? Do you see more states getting, foreign exception status, going forward?
Do I see? I think so. I think that we've already seen a number of states starting to change their foreign investment rules. The European Union had issued some directives that states were already implementing. So I think that we will see some added. I think it's going to be a slow process, as the U.S. is very careful. I do see that we have some questions, but I'm having a hard time the way my computer is working, really seeing them. Can you see them, Samir?
So yeah, I think there's one that is one here is, have you seen any changes to the purchase agreements that are currently being drafted related to CFIUS?
Yes, I think what I've seen is that there are much more specific reps and warranties around whether the U.S. business meets certain triggers, like whether, if we're talking about a minority investment, whether it's a covered a TID U.S. business. That's definitely something we're seeing in reps and warranties. In some cases, we've seen U.S. businesses producing memos to really explain their analysis as to why they're not a TID U.S. business. I haven't seen this really work its way into the agreements yet, but I've seen much more of a focus on due diligence into the buyer side to really understand who the foreign parties are who have some sort of ownership and investment stake in various private equity funds, for example. Okay, I see one question asking about the fourth company ordered to divest, and that would have been Patients Like Me. I think that's the fourth one that you're asking about.
Yeah, that's right. And then this next one, it says, this is, I guess, for you, Francesca, how is FIRRMA applied if foreign investors are creating new U.S. greenfield JV that has a TID, activities?
Okay, so if foreign investors will create a new U.S. greenfield joint venture. So joint venture, of course, is a loaded word, because generally speaking, in a joint venture, parties are, they're both bringing something to the table. If any of those things that they're bringing to the table are assets, like not just money, but they're like intellectual property, tangible property, developer rights, things like that. Those assets might be considered a U.S. business by CFIUS, so that the joint venture is considered like an acquisition of control of a U.S. business by the foreign party coming in. Now, if two parties are just putting money in and they're not contributing anything else, then that would be, truly greenfield and generally outside of CFIUS jurisdiction, even if it's a TID business. But if there's a contribution of assets, like a patent, like a design, then you might trigger it. And in fact, I'd say more than 10 years ago now, maybe 15 years ago, there was a case where the U.S. Blocked Huawei from acquiring some servers and some patent portfolios from this company called 3Leaf. That was a distressed company and was selling off those assets. And CFIUS said that the servers and the patents combined to make a U.S. business, and they asserted jurisdiction there. So yeah, joint ventures, I'd be careful, about what each party is contributing to the joint venture.
That's exactly right. I think the devil's in the details there. And so I think it's going to be the devil's in the details for any of these transactions. I do see one last question. We've seen broad construction of the term national security in the president's trade negotiations. Do you foresee CFIUS being employed in a similar way, or has it already?
So there's always a tension between people who want to read national security narrowly, I think, versus ones who want to broaden it to include economic security. I think that, in large part, CFIUS has resisted throwing it open, fully throwing it open is meaning economic security. But when you talk about things like supply chains and like essential industries, I think that there is perhaps some expansion. For example, agriculture. I think that agricultural supply chains have a little bit more scrutiny than they did 5 years ago, or maybe I should say 10 years ago. So I know Smithfield is obviously an important example, but I think there's been some expansion. I mean, Samir, what is your permit? Your sort of
I think that there's. Yeah, I think so. I mean, I think that obviously CFIUS's purview has expanded greatly just in the past 3 to 5 years. And I think that there's a number of ways that it can continue to expand and will expand into other areas that, I think our president has used the term national security to encompass a lot more than sort of other presidents before him. And so I think that's only going to continue. I do see that we're up against our time, so I do want to, I think we can close there. I do invite everyone to, if you're not currently receiving our updates and invitations, I do invite you all to go to the Thompson Hine website and register to receive our mailings under the Publications tab. Also, you can visit our blog, trumpandtrade.com. trumpandtrade.com. Please sign up to receive timely updates on the Trump administration's international trade activities and policies. I do want to note for everyone that we invite you to register for our upcoming series on the USMCA. You can access the registration from the Thompson Hine Events tab on our website. That series will begin in a few weeks on June 10th. So if you're seeking CLE for today's program, the tracking code is TH0527. Again, that tracking code is TH0527. Thank you all for your interest. Thanks for attending. Please enjoy the rest of the day, and everybody please stay well. Thanks.
Thank you.